We shall start now, sir.
Go ahead.
Good evening, ladies and gentlemen. Today we have with us Advocate Sai Sushanth. He is a cyber law expert and a techno legal consultant. So we have a topic known as telemedicine and law, and Advocate Sai Sushanth will be covering a number of areas under this. Over to you, sir.
Thank you so much. I first of all, very good evening to all the viewers of this webinar, and I thank Law Essentials for giving me this wonderful opportunity. And then I'm here to talk about a new concept that is called telemedicine and law. So I'd just like to start off with saying that telemedicine is not a new practice. It's a practice that started a long time back, but only it has gained center stage attention today because of this pandemic situation and specifically the lockdowns in the national and the world. So I think this is the fundamental area that is not very much spoken of because there are very few legal professionals in the country who are specialized and who are able to cater to this particular subject. And the word itself says telemedicine. So therefore, telemedicine is nothing but doing all kinds of your consultations and providing medical services by using electronic means, specifically the technology. So I just want to start off with some basic concepts, and then I would like to take you through the recent telemedicine guidelines that were published by the Government of India on 25th of March 2020, and also talk about some cyber legal essentials that doctors and medical practitioners intending to make use of telemedicine need to be aware of, and also to talk of some legalities relating to the telemedicine platforms, because there are enormous amount of platforms that have been providing telemedicine services, and then also to talk about privacy, because right to privacy is now being made as a fundamental right by this latest judgment of Supreme Court. I think that's also one quick area that we need to understand, and also taking you through the different kinds of legal due diligence, specifically for a doctor and a platform provider that needs attention here in order to ensure compliance to law and these regulations. So this is the whole objective behind my talk. We'll just proceed further. Can you go to the next slide? Next slide, please. This is the usual kinds of response I get from the face of people. So when I'm taking a session, more specifically from the non-legal audience, as well as from a couple of legal audience, because the subject is a very, very new subject, and that has required a lot of new legal, regulatory, and policy issues coming up. I think there is a lot of work that needs to be done today, because if I am to tell you that at this minute when I'm talking to you, if I were to write a book on telemedicine and the legalities, and I should assume that the book has about 50 pages, I think we are in the fourth and fifth page. There's still a lot of amount of work that needs to be done in this space. So with the growing technology and legal issues, I think there is a lot of scope that is likely to come up in this area. So all I would like to tell you is that this is a very new generation area, and then it could also be looked at from a legal perspective, particularly from a cyber legal perspective, as a boon rather than bane, because the technology has given us a lot of options today, and even sessions like these, webinars like these, have been possible thanks to the growing advent of technology and technological advents. I think more specifically, I would like to talk of some basic legal principles, and also talk about some emerging cyber legal principles in this area. Also, one another fact that I want to tell you is that lawyers, young lawyers especially, who are just graduating from law schools, and also people who are law students, can also try to take up this as one of their good career options, because there are lots of potential legalities and cutting edge legal issues that are cropping up on a daily basis with regard to telemedicine. More specifically, that the advent of technology has brought in a lot of different legal challenges and legal issues that one needs to consider. So just want to just brief you about all of these, and then thought of just taking you through some of the case studies that I've encountered, because I've been practicing in this area of technology laws and cyber laws from the past 7.5 years. And we work closely on the intersection of law and technology. And more specifically, telemedicine also has been one of my areas of practice. We've been helping and advising clients across the globe on this area. So just thought of sharing some real-time scenarios so as to ensure that you have some value derived at the end of the day. Next slide, please. So telemedicine and law, there are no standard regulations as such before these guidelines stepped in. Prior to these guidelines, we only had a lot of different views from various courts. Specifically, I would like to talk of some case studies and also highlight certain key judgments made by the Supreme Court in this direction. So ultimately, what I want to tell you is that if you're a patient, or if you're a doctor, or if you're a telemedicine platform provider, if you're dealing with any of these seven things, I think you must be aware, you must tighten your belts that there is a different law that you need to comply with. So if you're dealing with computers, computer systems, computer resources, computer networks, communication devices, as also data and information in the electronic form, well, it's time that you wake up, because there is law that is newly emerged, and that's all called Information Technology Act 2000. It's the key cyber law in India, because we have also some rules and regulations made there under. We have the Information Technology Rules 2011, specifically relating to reasonable security practices and procedures. Information Technology Act also has been amended in the 2008, and the whole regulations that we are going to talk of will be specializedly looking at these areas, apart from the regular law of torts and consumer protection laws, the Indian medical laws, as well as the Drugs and Cosmetics Act and the like. So just want to tell you that the moment you're handling, processing, or dealing with any of these seven things, I think we must all be alive to the fact that we require the knowledge of cyber law, and we need to be compliant with this law. Why? Because it's the only law that is digital in India. So after Indian Telegraph Act, which came in the year 1885, after 115 years, there was a completely new legislation that came up, and primarily it was intended to promote e-governance and e-commerce. So at that particular point of time, India was not having any regulation to give electronic recognition or legal recognition to electronic records or electronic transactions. And it was at this point that the Information Technology Act stepped in and brought about this legal recognition. So whatever you're using today, I think primarily the aspects of telemedicine are all electronic records. Why? Because whether it's the consultation, whether it's the data, whether it's the patient information, whether it's the patient's records, or whether it's the prescriptions generated, I think all of this, end of the day, are made using computers, computer systems, computer networks, as also communication devices, and by and large include the component of digital and electronic data, thereby itself classifying themselves as electronic record. So once they're under the gambit of electronic record, I think there are lots of things that we need to understand. So we'll go through each one of them in a stepwise manner, so as to ensure we cover, by and large, almost all the legalities surrounding to telemedicine. Next slide, please. Yeah, now the question arises, who can practice telemedicines? Now the regulations and the guidelines are very clear. They come with something called RMP, Registered Medical Practitioner. So if you're an RMP, you can and you are eligible to make use of telemedicine for the purpose of consulting and making advisory services to your patients. So who is a registered RMP? The act is very clear. The regulation is very clear in saying that, yes, if you're a doctor registered under the medical Indian medical register, and if your name is typically enrolled with the state medical register as an practicing doctor or as a medical professional, and if you're specifically registered yourself under the Indian Medical Council Act 1956, you qualified as an RMP. So what happens if you're an RMP? There are a variety of things that you can now make use of, thanks to the guidelines being published under the name of telemedicine. Next slide, please. So in short, I just want to tell you some things about the guidelines, then we'll touch in detail about what the guidelines are. I just would like to just put this in a nutshell. So if you're an RMP, if you're a doctor, and you intend to make use of these telemedicine services, yes, the law has now come up with some guidelines, and the guidelines have given certain parameters and certain duties of compliance which you need to do as far as the guidelines are concerned. Number one, if you're an RMP, you must first have your registration number and other details, and also a certificate of practice under the Medical Council Act. That's the first qualification. The second thing is that you will have the option to choose what kind of consultation you can look for. The regulations give you three kinds of options. You can do an audio consultation, you can do consultation through video, you can do consultation through text message. So ultimately, you have the ability as a doctor to choose and make use of your discretionary measures in order to determine what kinds of mode of consultation that you intend to do. So this is one more area that you can opt depending on the nature and the requisite and the respective position of the case. So it can be on a case-to-case basis. This is one more guideline that the guidelines have come up with. Now the next area is what if I'm a doctor, I have all these requirements and I intend to do my telemedical practice. So I can make use of any of the proprietary software concerns. There are lots of platforms. I can also make use of some applications like over-the-top applications, yes, for conducting my telemedical consultations. So the second thing is that I need to be aware is I need to have a proper, duly compliant telemedicine platform that I need to choose. So we'll also be discussing on those areas as well. So this is one area that you need to keep in mind. Now the next area that I would like to tell you is that no Internet of Things or artificial intelligence or automatic softwares can be used in telemedicine consultations for prescription of medicines or for doing any diagnosis. It's ultimately the human mind that has to do the diagnosis and prescribe medicines, and these tools can aid in doing your telemedical consultation. So this is a very, very important point, because a lot of times there are a lot of free tools. There are also some fancy tools that are available across the globe or over the internet that give you the option of diagnosing and also prescribing medicines by using this latest enabled technologies. I think we need to clearly get ourselves right that these regulations prohibit the use of these technology related what do you say, platforms for the purpose of diagnosis and prescription. You can use it for generating your telemedicine consultation. You can use it for collecting information, disseminating information, diagnosis, you're doing your diagnosis, human diagnosis, I mean. So you can make use of platforms, but per se you cannot make use of technology and automation for doing these two important aspects. One more important aspect that I would like to tell you is that you can no longer do anonymous or non-identifiable conversations on telemedicine. That means the identity of the doctor and the patient has to be crystal clear. So though the internet allows you to do a lot of anonymous consultations, but the guidelines are very clear. They say that no anonymous consultations are possible, and the identification of a doctor and a patient should be made in a very clear and distinctive manner. So how do you do that? The first step is identify yourself. So self-analysis and self-introduction would be the first way to get into telemedicine practice. So that would bring in some kinds of idea regarding that. And then the next option that you would have is collecting information from the patient. So you have to identify the patient with their name and with their details provided. And then before you proceed, the most important aspect is taking consent. I think consent is one of the most key essentials that one needs to consider while making use of telemedicine practice. This consent, as a law student, as a lawyer, as a practicing legal professional, we are all aware that once there is a contract, the contract can be only legally held enforceable only if the consent from both the parties are absolutely free. So there has to be a free consent, and consent has to be captured in a way where it is going to be legally acceptable. So there are no specific guidelines as to how this can happen, but I will just try to interpret these guidelines in terms of the cyber legal provisions, and then we'll be able to throw some light on that as we go forward. But once a consent is given, I think only then your telemedicine consultation can be possible. So once you collect the consent and start doing your telemedicine consultation, I think you can exchange a lot of information, diagnosis can be made, and prescriptions can also be exchanged thereof. Typically, when you're prescribing, there are also certain limitations that the guidelines have come up with. I will also say that in a while. But in a nutshell, I think all of these is what the guidelines talk about. So if you're a doctor, in a nutshell, I would just like to tell you that there are 8 important parameters you need to comply. First, you need to be an RMP. Second, you need to make use of a platform that is duly compliant with the law. Then third, you must exercise your due diligence while you make use of the platform. Fourth, you're supposed to be clear in identifying yourself and the patient. Fifth, most important thing is getting a consent from the patient with regard to telemedicine consultation. And next, you can opt for the mode of consultation depending on the severity of the case and the kind of medical issue. So you will have an option to choose the type of consultation. And then once you do that, you can also try to go further in your diagnosis. And the next step that you would be required to do is you can also exchange a lot of information. You can ask requisite questions to the from the patient in order to get in his medical history and the details. And then you can make up a prescription, and then you can share that across. And then that's apart from that, there is also three more aspects that you need to understand. Next, first thing is talking about the patient confidentiality, the records, as well as how do you store these records, and what are the due diligence mechanisms arising thereof. So this, in short, is something about the guidelines. I thought of just sharing that with you so as to ensure that you're in the right direction when you're trying to make up your telemedicine consultation. So next slide, please. Yes. So this is all that I was talking to you about: self-indication, consent, patient management, records, personal data, prescriptions. Yes. Next slide, please. I thought of just sharing with you an interesting case. This case is called Deepa Sanjeev versus State of Maharashtra. And then this typically was a case which was decided by the Bombay High Court in the year 2018. And two gynecologists, doctors, were denied anticipatory bail, and there was a clear case of medical negligence, and criminal case was lodged against them. Why? Because in this particular scenario, I will tell you that what has happened in this scenario. A husband and a wife went to the nearest nursing home, and the wife was suffering with a fever and severe vomiting. And then, unfortunately, there were no doctors present in that particular hospital, and the nurse was there. So she started interacting with these doctors, and then the treatment what was prescribed by the doctors over the telephone without even understanding and properly diagnosing and giving proper treatment. And as a result of this negligence of the doctors, it resulted in the death of the patient. And the court has awarded a compensation of and apart from that, these two gynecologists, also a criminal case was lodged for criminal negligence. So how this kind of a scenario has happened? So it's very simple that I was just relating to the guidelines, right? So I will draw a line between what are these guidelines and what are these to do with this particular case. So in this particular case, when you look at the guidelines, I clearly told you that you need to ensure that you make use of appropriate kinds of consultation. You could do a consultation over the phone, you could do that on a video, or you could do that on a text. But in order to understand which is the appropriate one, you need to clearly apply your mind and take a duty of care as to which is the mode that you would actually like to treat the patient. So depending upon the medical issue and the severity, I think a doctor needs to clearly make this distinction. And if a proper distinction is not being made by the doctor, I think this case is a clear demonstrative case that is talking about how a criminal case can be filed against the doctor for medical criminal negligence. I think this is a very, very important topic that doctors and as well as we as lawyers need to keep in mind when you're addressing or advising the hospitals or the medical fraternity, because choosing the right kinds of consultation method is going to play a very key role in terms of telemedicine. This is a very important scenario that I would like to talk of. Next slide, please. This is one more case that I thought of just sharing with you. It's called the Kunal Sanha or Anuradha Saha case. So this case was filed in the year 1998 against a hospital called Amri Hospital and its staff. And here in this particular scenario, there was again a husband and wife. The wife was suffering with some kinds of drug allergies, and doctors were negligent in addressing that, and then they were given medication without even looking into that area. And the husband of the lady was going on talking to the doctors, advising them on this particular scenario, but they played they did not pay any attention to this, and despite the lurking danger that was pointed out, they exercised uh, their negligence, and no proper duty of care was exercised by these doctors, and as a result, this resulted in the death of the patient. And of course, the Supreme Court, in validating this particular judgment, has given enormous consideration, because look at the compensation being awarded. It's 2.08 crores that was awarded. So I think it's one of the very important cases, because it has given a lot of value to the human life, because the quantum of compensation can be one such area that you can look into. I don't say that yes, this is the be all or end all. I only wish to point out that this could be one of the areas that doctors and medical practitioners also should be aware of, while in order to ensure that they're not doing any kinds of negligent activities. So this is one more area, I think, where it becomes very important in terms of telemedicine, because when the doctors are typically collecting the patient's records and patient's history, medical history, over the technology platforms, I think it's very important that they stay alive to the fact and they make proper observations. I think this is one more area and one more duty of care that I would like to talk of from a legal perspective, more specifically from a cyber legal perspective, because end of the day, all these are nothing but electronic records under the Information Technology Act. So I would advise and I would urge that this is one more area that the doctors or the telemedicine practitioners will need to increasingly look at while they're making up their diagnosis, and while they're trying to analyze the medical condition of the patient. So this becomes very important in this area. So unlike the physical world, where a lot of information is actually collected by various people, when you go to a hospital, typically there are lots of departments which ask you for your antecedents, or they collect the patient history. But unlike this scenario, in terms of telemedicine, it's going to be you as a doctor who is going to exercise duty of care and diligence, to ensure that you collect proper medical information and history from the patient while doing the diagnosis. So this is one more area that will talk about the liability of the doctor in terms of negligence. And then I think I thought of just putting up this case in order to ensure that the doctors are also clearly aware of about what is negligence in terms of this particular case. Next slide, please. WhatsApp. I think WhatsApp is now supposed to be the de facto mode of communication in India, thanks to the technology and rapid adoption of it. WhatsApp is now gone ahead and said, yes, we are encrypted, we're end-to-end encrypted, and there have been lots of security measures that they have in place. Well, I see that there is a lot of misconception happening over this particular information. So I just thought of sharing it in the interest of the people, as well as lawyers, law students, as well as the doctors and telemedical practitioners, as also the telemedical platforms. A lot of us, once you look at the guidelines of the telemedicine, which has been published by the government of India on 25th March, we quickly realize that the guidelines very specifically state that you can use technologies and applications like WhatsApp. Now, this is a very, very important aspect that I would like to highlight. The guidelines have never endorsed WhatsApp as a de facto mode for conducting telemedical consultations, nor have they given any legal sanctity to transactions or any kinds of interactions that have taken place over WhatsApp. Primarily, as a law student, as a cyber law student, I was just going through the terms and conditions of WhatsApp, and I found that this is a very, very important aspect that I would like to just talk to you. When you look at the terms and conditions of WhatsApp, I'm clear. They say that whatever information that you publish, whether it's audio, video, image, or text, whatever information you're publishing on WhatsApp becomes information in the public domain. Once it becomes information in the public domain, you can no longer call that as a sensitive personal data, and neither any legal remedies can be sought for information in public domain. So it's going to be a very, very different kinds of a ball game. More specifically, in the light of telemedicine consultations being consulted through WhatsApp. Now, with WhatsApp, I think there are lots of lurking dangers. I think it is opening up a Pandora's box of legal exposures with or without the knowledge. There are lots of doctors, as well as medical professionals, as well as a lot of platforms endorsing that you can do your medical consultations, telemedical consultations using WhatsApp. I think you need to quickly realize and exercise your due care and caution in this regard, because though the intentions are noble, I think the law is very clear. So once you are ignorant, I think ignorance of law is no excuse in the eyes of law. So as a law student, and more specifically as a cyber law student and a practicing professional, I thought of just bringing in this point and highlighting this, because I intend that none of the doctors who are practicing telemedicine or making use of telemedicine consultations would be advised to make use of WhatsApp specifically for the purpose of conducting their telemedical consultations. I don't wish to demean or affect the downloads of this application, but with due respect and care, I just would like to just caution you. So it's just like closing your eyes to the sun and saying that the sun has gone away. So that's not what it says. So I think we clearly have to be alive to this fact while making use of WhatsApp as a mode for telemedical consultations. Next slide, please. Um, there are some cyber legal considerations and due diligence mechanisms. I thought of sharing it with you while you're making use of your telemedicine platform. Well, if you're a doctor, if you're a medical professional, and if you're also a lawyer who's advising on this area, I think this is one such area that you need to clearly uh, keep in mind. Why? Because the law is very clear. Now, any platform that is providing telemedical services is now called an intermediary under the Information Technology Act, more specifically under Section 21W. So this definition is very broad in saying any platform or any individual who collects, processes, or stores or handles sensitive personal data or personal information or electronic records, and provides any respective service with respect to that record, is an intermediary. So therefore, telemedical platform is an intermediary. A doctor who is making use of telemedicine is also an intermediary. So this is not largely spoken of in any of the guidelines, but the guidelines have brought in reference to the Information Technology Act and the rules and regulations made thereunder. So specifically, we need to understand that while making use of any platform, if you're wanting to choose a platform, I will say there are no magical phenomenons or golden rules, but I would like to say if you should just look at three aspects. One, is there a privacy policy? Now look at the privacy policy. I know that you're not lawyers or you're not doing anything in the terms of law, but I would like to tell you that you must have a privacy policy and you must have compliance to Information Technology Act. So Rule 3 specifically, subsection 1 and subsection 2 mandate that every website or an intermediary or an application has in place a privacy policy. So the essentials of a privacy policy are also there, but I would like to tell you that look at the privacy policy of the platform. Is it using the term Information Technology Act? Yes. Then look at it. Then it must be able to also showcase that sensitive information has been collected, personal information has been collected. We'll come to it in a while, what is sensitive and what is personal. But just would like to tell you that looking for an adequate amount of privacy policy. Then the second thing is ensure that there is a grievance officer. So grievance mechanism is one more such area that every platform who's into telemedicine should be actually complied with. So there needs to be a specific grievance officer. The name, the contact number, the email ID has to be mentioned. And in case of any discrepancies relating to privacy issues or any other issues, I think clearly the grievance officer has to address this, and he's given a maximum of 1 month time as far as his guidelines are concerned to address the same. So I think more specifically, you have to ensure that there is a grievance mechanism or a grievance redressal officer. A third important aspect is look at the terms and conditions. Most of us do not read out the terms and conditions, but more specifically, I would advise you that you should look at the terms and conditions more specifically in the light of sharing of information, sharing of these audio video records or information or the videos or the audios and the like. Why? Because the telemedical consultations have brought in a variety of cyber legal implication. Number one, if you're trying to misuse the photographs or videos of any of the patients during this process of telemedicine, I think it amounts to professional misconduct as far as the guidelines are concerned. So much so that anything going on the social media without prior consent and permission, that is also considered as a professional misconduct. I think the doctors and the medical practitioners need to stay alive to the fact that this is one more area that you need to look at. So please look at the terms and conditions of your platform provider, more specifically in the light of privacy and in the terms of content, in the terms of storing of this information and facilitating this information, and have they done due diligence. You'll also have to ensure that they have used these things in their terms and conditions. More specifically, on regarding what kinds of data is shared, with whom all is it shared, what is the purpose of sharing. I think all of these also needs to be specifically looked into by the doctor or the medical professional before they make use of the platform. Why? The regulation is very trickish in this regard. A lot of people say, okay, I'm not a lawyer, I'm a doctor. Why should I really be bothered of privacy? Because that's not something that I'm going to really be bothered of. Well, I'm making use of a platform. Anything going wrong in the platform, well, I'm holier than thou. I'm going to be exempt. I think that's a clear misconception. The regulations have clearly put in a lot of onus and responsibility on the doctor in order to choose the appropriate telemedicine platform. I think if you're basically able to do your due diligence, how will you be able to demonstrate that you've done your due diligence? Well, if you look at these three aspects while considering a telemedicine platform, I think you've done your due diligence, basically. The moment you've done your due diligence, I think the law will come to your rescue. It's so there will be clearly an exception to your liability. So this is one such area that I thought of sharing it with all of you. So in the light of choosing a platform, and then what are the essentials and the due diligence that you need to do. Next slide, please. Consent, like I said, is going to play a vital role. Now, what really happens in this kind of a scenario is, I would say that there is no proper format or such which is prescribed under the guidelines. But all I want to tell you is that yes, you can make use of these kinds of information. You can clearly state that the consent should probably include the fact that the patient is consenting to telemedical consultation. So the fact that telemedicine consultation is happening has to be specifically mentioned in the consent. So this is one more area that a lot of doctors or medical professionals need to be alive, because the moment they're making use of telemedical consultations, I think the first thing that they need to include in the consent with the patient is the fact that it is a telemedicine consultation. So that is one of the key essentials. And the second thing is that they would have the right to go ahead or to withdraw at any time. So the guidelines are very clear. You can give out your consent. At the same time, they should also be given an opt out. So it's important that the consent is not just I agree, but it's also I decline. So in order to opt out of telemedical consultation, the process also needs to be defined. Why? Because specifically, this reference to consent has been drawn to Information Technology Act, more specifically because this consent is collected electronically. And once it becomes electronic, it becomes an electronic record. I think more specifically, we need to ensure that whatever be the mode that you're collecting the consent, I think you need to ensure that a valid consent is collected. And more specifically, if it's going to be a minor, it's going to be, as a law student, you're all aware, or as legal professionals, you're all aware that any contracts or consents with regard to minors have to be done by the parents or the guardians. Failing which, that will make the whole consent invalid. So that is one more area that I thought of emphasizing on. So this is one more area that increasingly doctors and the medical practitioners who are making use of telemedicine to be aware of. So I accept and decline has to be given. In case they decline, I think that also needs to be specifically pointed out. And more specifically, the doctor would have an option either to provide consultation, or he can also have the right to deny the consultation. So he can also opt in and opt out, basically. So the collecting the consent should also have opt in and opt out. And more specifically, consent also needs to address the privacy aspects. So this is not what's very well spoken of, because normally you think that the privacy is just relating to the information, but it's not relating to anything else. No, I would say that whichever be the mode of consultation, whether it's audio or video or it's a text, I think we need to very specifically take consent for the fact that this privacy also will be protected, and consent for actually getting yourself examined through a teleconsultation also have to be provided. And more specifically, I think also you need to ensure that the confidentiality of the data has been maintained. So I think in this regard, I think these are the four things that I would like to keep it on the uh, stand. I think four things. First thing is opt in and opt out. The second thing is confidentiality. Third thing is consent regarding privacy. And fourth thing is to ensure that yes, in case there is any issue or any kinds of technical glitches, it will be the provider responsible and not you. I think these are the four things that you need to keep in mind. Now let's go a bit more further on it. uh, Next slide, please. Patient's data is going to be a very critical aspect, because the guidelines are very clear in stating that, look, if you are doing a telemedical consultation, you will have to maintain the confidentiality to the data. More specifically, that this data, if you're making use of third party tools for the purpose of doing your telemedical consultations, that is going to bring in a lot of legal, cyber legal challenges and liabilities. Why? Because the patient's data, the patient's information, what kinds of liability would it amount to in case I'm storing such information on a third party server? Well, that has to be looked into. Specifically, you need to have an awareness into also understanding the nuances of the privacy aspect and the confidentiality aspect with regard to the patient's data. And more specifically is that, one second please. And more specifically that I would like to talk of here is that you must ensure that this data, whatever is provided to you, is free from any kinds of unauthorized access. So you should not share this information with anybody. You must ensure that you have reasonable security practices and procedures. So I would also advocate that apart from taking consent for doing the telemedical consultation, I would also advocate that the doctors or the medical professionals also have a policy which is specific to the patient's data, so as to ensure that no privacy breaches can happen thereof. And more specifically, today we are living in the digital era. I think anything and everything can be prone to cyber attacks. When you look at this, I would just reminded of one instance. I think when you look at the pandemic situation that we are all into today, one of the first things that have happened in the Western countries is the Bruno hospital case. It was a hospital wherein a cyber attacks have taken place, and it was one of the first corona specialized hospital in the Western countries. And there was a data breach which has compromised the personal and the medical information of a lot of patients, and then that created triggers, and that opened up a lot of Pandora's box of legal exposure. I think quickly we have to understand and realize that a specific policy has to be defined in terms of protecting the patient's data. So I would also urge you to have a proper policy for this, in order to ensure that the privacy breaches will not have any kinds of impact on you, because that will demonstrate your due diligence under the regulations. So I think clearly one has to clearly keep in mind that the issue of privacy and confidentiality will come into picture, and not just of theirs, but also sometimes it is required that you know the family history in order to diagnose some certain uh, medical issues. So it becomes important that you just not only protect the privacy and confidentiality of the patient, but also their family as well. So this is going to be very important. And then any inaccuracies or improper disclosure, I think the onus is completely on the patient. So I think that is very clear. So we don't have to do anything with regard to that, because the accuracy of the information is completely on the patient. So but we need to ensure that the information given by the uh, patient is adequately protected, and it's not having any kinds of unauthorized disclosures. Uh, and more specifically, we should also ensure that the platforms that you're making use of also adequately protects this in case of storing the data therein. And more specifically, right to privacy is now made the fundamental right according to the latest judgment of the Supreme Court. So in this line, it becomes very important that you not only protect the data, but also protect increasingly the privacy of the respective patient. So patient's privacy also has to be looked into specifically by the doctors and the medical practitioners while making use of telemedical consultations. So very fact that, see, there is a lot of thing we call usually this as a doctor-patient relationship. So what happens in this scenario? A doctor is not supposed to disclose any kinds of personal information regarding the patient which is gathered during that course of examination to anybody other than for the purpose of giving the treatment. So usually this is what is the general understanding doctor and patient relationship. So there is something that we need to keep in mind. There is also that basically no commercialization is supposed to happen in this regard, and any doctor who's is indulging in these kinds of practices would be morally, ethically also be subject to data breach and data privacy breach and confidentiality breach. So this is one more area that I thought of just focusing into. It also applies equally to the legal profession as well. But however, I just thought of bringing in that aspect. So essentially, doctor and patient relationship also holds the key in terms of telemedical consultations. Next slide, please. So the law has quantified and come up with something called sensitive personal data or information. When you look at that specifically, passwords, financial information, biometric information, sexual orientation, that is your gender related information, health conditions and health records, medical records. All these are also forming part of sensitive personal information under the law. More specifically under section 43A, read along with IT rules 2011, talk about the sensitive personal data or information. Next slide, please. The law has also come up with the definition called personal information. Any information with which you can identify an individual can be called as personal information. And then clearly, even the blood group and the patient's health and medical records can be considered as a personal information. So any attribute that can immediately relate to a natural person can be called a personal information. The name, phone number, email ID, medical history, and blood group, and any other parameters. I think when you're collecting, processing, storing, or making use of this, you will have to ensure that you have in place reasonable security practices and procedures. So I would advise all the doctors and medical practitioners to have an understanding of what is sensitive data and what is personal data, so as to ensure that they are duly diligent while exercising their work of telemedicine consultation. Next slide, please. A liability. No, generally we have something called, this is generally regarding the general liability and law of torts. Yes, medical negligence has been given an exception under law of torts. So tortious remedies cannot be invoked by the patient. Okay, but there is a restriction. If a doctor is not charging any fees for his consultation, then he cannot be sued. Is what is the general principle for torts or in consumer courts. But this is as per the definition given under section 2, specifically subsection L and O of Consumer Protection Act. So this applies very well in terms of normal consultations. But when you talk specifically about these liabilities under the telemedicine guidelines, I think telemedicine guidelines have not carved out an exception between free service and paid service. I think end of the day that also has to be understood, that in case a doctor or a medical professional is not adhering or is not complying to the guidelines of the telemedicine, he definitely can be subject to legal liability. So that's all I can say as far as the general liability of torts is concerned. Next slide, please. And this is one important case that I thought of sharing with all of you. It's Indian Medical Association versus VP Shanta. So the citation is already given on the slide. So it also brings in a question of whether a medical profession is covered under the ambit of consumer protection law. So whether to determine whether the medical practices are coming under that particular section or not, the law has what he says, the Supreme Court has come up with two guidelines. One thing, a rendering of personal service and rendering service free services. So what is rendering of personal service? So there's a lot of difference between contract of service and contract for service. So contract of service in a legal scenario, if I were to explain this, I would tell you like this. It's basically something like an employee employer basically. So in an employee-employer scenario, what will happen? You will just follow the instructions given by the employer. So the employee's liability will be limited in this scenario. But contract for personal services is just like an independent contractor. So wherein you are different, they are different. So exercise of due care and diligence has to be done by both the parties. So in this scenario, contract of services and contract for services is a lot of difference. So when you're doing contract of services, you are exempt. When you're doing contract for services, you are liable. This is what this particular case lays down, and this is one important thing that I would like to highlight, specifically in terms of telemedicine, because a contract for service and contract of service is a lot of difference. So I think we need to clearly keep in mind the distinction. So independent contractors and employee and employer relationship. These are the two classical examples that I would like to relate here. Next slide, please. See, one of the other things that I would like to talk of is another High Court judgment, which is given by Assam High Court. Yes, here the patient has sued the hospital for failure to provide services. And in addition to his claim for damages, yes, he also told that there needs to be some kinds of upgradation to the hospital services that are required. Well, a compensation was awarded in this scenario, and also, of course, there were also not presence of any doctors there. So the High Court has also directed that doctors have to be adequately present in that particular government hospital. So apart from that, a compensation was awarded, and apart from that, I think also it brought about certain issues relating to upgradation of the hospital's services in order to provide better treatment for patients. And this is one more area that has to be looked into. So that sort of just bringing into this scenario. Next slide, please. Some important aspects relating to medical practices, medical malpractice, or medical negligence. Yes, I'm sure these are all just preliminary sections, but I just thought of just collating that with you so as to ensure that you are aware of it. 304A, of course, causing death by negligence. 52, when you're doing something in good faith, uh, well, I think if you're acted in due care and attention, you will be exempt from liability. So this is one more aspect that I thought of just sharing it with you, because good faith, due care, and attention will be center stage words that we need to understand. Next, coming to the next section of 80, accident and lawful act. If you've done anything in a lawful act, I think there's still the law will give you some kinds of an exception. 81, an act that is likely to cause harm but done without a criminal intent and to prevent other harm. This is also one general aspect that I would like to point out in this scenario. So I think there was one. I'll also share one or two cases that have come to me here. 304 is, of course, again, a culpable homicide not amounting to murder. 337, 338 sections also are to be looked into, specifically when analyzing medical negligence and medical malpractice. These are all some general regulations of the law of crimes, but I thought of just highlighting them because I thought of just informing and bringing to notice these sections and these paradigms to all the doctors so that they're at least basically aware of what is what in order to go forward with their telemedical practice. And more specifically, to apply this in terms of telemedicine becomes one of the challenging aspects. Next slide, please. So consent, I already talked to you about. It's going to play a very, very vital role, free and informed consent. And it's very important that you capture free consent. So consent has to be not from any coercion or by force or by compulsion. I think free consent. So the wordings have to be put in such a way that free consent is also captured. Next slide, please. I think there are some also consents that have been. There are also some sections under IPC which talk about the consent specifically. So consent is. I mean, I just want to tell you that yes, anything done in good faith or benefit without the consent, there's an exception. But however, when you look at the telemedical consultations, I think this becomes a challenging aspect because telemedicine guidelines very specifically talk about taking consent before proceeding further. Uh, and consent has to known to be given under fear or misconception is not a free consent. That also needs to be understood. An act not intended to cause death done by consent in good faith for persons on benefit. Yes, this is a very important scenario in terms of medical law because sometimes what happens is a patient may be suffering with some kinds of issue and you have no intention to cause any kinds of death or harm the patient. You do that in good faith for the benefit of the person, then I think yes, this section can be invoked in those cases. So this is one important section in terms of medical practice. Now, 87 talks about the consent not intended and not likely to be causing any death. Okay, if you're consenting basically to do anything, I think that's something that has to be considered. These are all just presumptions because the word consent can be interpreted in terms of IPAC as well. So I just thought of just bringing forward these questions also because it's going to be a very interesting space of how to interpret consent specifically in this manner because the interpretation of consent is not specifically mandated or mentioned specifically under the telemedicine guidelines. Next slide, please. Patients' records are going to hold a very, very key parameter in this regard because, like I said, they're all forming electronic records. I think the moment they're electronic records, IT Act will come into picture. and then storing of the information is also going to become an important role. So when you store this information, how secured are you? So what kinds of security mechanisms you have in place? Because the patient's record management is not specifically dealt in the telemedicine guidelines. Of course, our reference has been given to Information Technology Act and the guidelines met thereunder, because these are ultimately nothing but electronic records. So the moment they are electronic records, I think we must ensure three things. First thing, comply with the law. Second thing, exercise due diligence. Third thing, do not partner yourself with somebody who's violating the law. So my suggestion would be, once you have these patient records, whatever be it, reports collected through text or audio or video or medical history or prescriptions, everything, they have to be maintained by the doctor himself, and they have to be maintained in such a way that they are maintaining confidentiality. So how do you ensure that you have reasonably good practices? Have them put in a password protected environment. Ensure that there are some due diligence mechanisms that you do not share them out. Do protect them using firewalls or encryption methods. You can make use of certain basic things. For example, physical, you can have an access control mechanism. Well, with regard to this data, technical, you can have some antivirus and other tools that are downloaded onto the system. Update that system so as to ensure that there is no breach happening. And managerial, when you're managing that particular data or system, ensure that there is a proper what do you say, guideline as to how that patient's information is managed and operated. I think these are just the basic principles that I would like to highlight, because there are no specific guidelines as such with regard to patients' record management anywhere. So this is just in terms of best practices, I can say, reasonably secured practices. So these are some essentials that a doctor needs to keep in mind. Next slide, please. So more specifically, there are also going to be privacy issues. I've also spoken about the privacy issues. And when you talk about, see, I got a question that, what is the word privacy is not defined anywhere. How can you ensure that telemedicine law has this? Yes, the privacy is not defined anywhere, but what we need to clearly understand is when the guidelines have talked about data privacy, they have made a reference to Information Technology Act and the rules and regulations they have made there under. So what happens is specifically interpreting that in terms of the data privacy and the privacy of an individual also has to be understood in that regard, because the moment you're making a video consultation, I think the privacy of an individual also will come into picture here. So it's not going to be just data, it's also going to be the video and audio of the particular patient who's going to be amount to privacy aspect. So apart from privacy, there's also going to be a cyber security issue that we need to keep in mind, because what kinds of security measures are your telemedicine platforms having in place? That is also one thing that we need to really have an understanding. What kind of security measures are there in place? Who can have access to this data, and how are you clearly protecting it? Like I told you, having specific levels of best practices or reasonably secured practices would enable you to give some kinds of cyber security to this particular data. But however, this is going to open up a lot of gray area, because everything can be smooth unless something that some kind of a breach takes place. So I think these are just early days of telemedicine. I think we need to just realize that we need to have basic cyber security principles also adopted: confidentiality, integrity, and authenticity. These are the three principles of cyber security. So I think these are also have to be understood in terms of protecting the confidential and the privacy of the prospective patient. Next slide, please. So all these, and see, end of the day, what I want to tell you is that any transaction, whether it's the consent, whether it's the patient information, whether it's a patient's diagnosis, whether it's a prescription, whether it's anything that is generated out of this telemedicine, is ultimately nothing but electronic record, and it can still be used as legal evidence, more specifically under section um, uh, 421T of IT Act, which talks about electronic record, and section 65 and 65B, which talks about the electronic records admissibility. So there are a lot of legal challenges that would emerge, but all I want to tell you is that yes, with regard to electronic evidence, all of these are electronic evidence, and they can still be used validly in a court of law for doing any kinds of raising any kinds of legal issues or litigations. Next slide, please. Now, telemedicine is also going to bring about a very huge ambit of jurisdictional issue. I would also like to talk about this in two ways. The first way is the guidelines have clearly stipulated that these are going to be applicable only for Indian doctors and Indian patients. Okay, now let's consider a scenario. Okay, I'm not in this particular country. I leave to some other country, but I'm there. Okay, or my friend is who's got stuck due to this pandemic situation abroad. Can I make a video call, or can I do a video consultation with my family doctor? Well, telemedicine guidelines will bring in those transactions to be invalid. Why? Because it's not covered under the jurisdiction of India. So more specifically, jurisdictional issues are also likely to crop up, since the technology is a totally boundaryless world. It has made, thanks to the technology, it has made history. It has made the total geography as a history. So there's no boundary at all. Anybody sitting anywhere across can make use of telemedical consultations. So likewise, any doctor who's typically an Indian resident got stuck in any of the other countries would wishes to communicate something to their patients. I think they cannot also do these kinds of consultations as far as the guidelines are concerned. So this is also going to pose a lot of jurisdictional issues. Next slide, please. So the validity of legal prescription is absolutely one such area that we need to look into. The guidelines have stipulated that the prescriptions need not be in a particular format. However, if you're basically able to have some basic informations like the doctor's name, registration number, the patient's name, and the medical information and the drugs. Even while prescribing the drugs, the regulations have come up with certain guidelines. Also, O, A, B, and these are some guidelines that have been given. So basically, you can prescribe over-the-counter drugs, but you're not supposed to prescribe any kinds of drugs that are possibly likely to have narcotic or psychotropic substances. So this becomes a very important aspect, that you as a doctor do not prescribe those medicines. And more specifically, if they are something that have been regularly used for you know the issues like blood pressure or diabetes or anything like that, yes, there are also some common drugs which have been used. So that is one more such area. And the next is painkillers. So I think that these are some kinds of regulations with regard to the medicines and the prescriptions. But prescriptions ultimately have to be signed, and this becomes an important aspect here. So I would like to tell you that any prescription is going to be considered as an electronic record, because it's going to be generated out of generated by using a computer or a mobile phone. So typically, a digital or an electronic signature has to be affixed, ideally, in order to authenticate that electronic record under the IT Act. So specifically, I would say that there are lots of tools which are available. You can take a digital signature, you can take an e-signature, and you can make use of the same in your prescription, so as to ensure totally that you're complied with the prescription requirements as well, so as to ensure that the prescription, whatever you give, is going to be legally valid. So this is one more area I thought of just focusing on. Next slide, please. Yes. Now there are also some legalities that is going to arise in terms of prescriptions. Now, since the complete onus of providing information relating to patients is on the patients, so it becomes very important that we exercise that, because if you don't do that, then wrong prescription could be sent to the wrong person. So then that could involve a lot of legal issues, and not only that, it would also be one more area wherein the prescription to minors is also going to be a difficult issue, because like I said, contracts with minors would not be deemed legally enforceable. So this is also one such area that I would like to just make you aware, because telemedicine consultations and the prescriptions for minors have to be specifically also addressing their respective parents or the guardians who have represented the respective minor in this consultation. So it becomes so much so important that the doctors also need to quickly realize that they have to keep that is also in mind. Next slide, please. So what is necessary is only what is required. So I know there are lots of things that could be spoken of in this area, because it opens up a lot of areas for discussion as well. But all I want to tell you is that there are lots of legal issues that are arising out of these telemedicine practices, and there are lots of unanswered questions, and a lot of ambiguity in terms of interpretation of these guidelines. I think all I should tell you is that so long as we are able to do our due diligence and able to comply with the law of the land, as well as this telemedical consultation, and also exercise duty of care, I think we are protected. So not doing any of this could expose us to criminal liability, civil liability, as also liability under the Information Technology Act specifically. So this is all that I have to tell you from my end. And one or two instances that I thought of sharing it with you is that I got this wonderful case of, now that everybody is looking into telemedical consultation, I got this case of a veterinary doctor who was talking to me about, doing a telemedical consultation for pets specifically. It so happened that one of the pet owners raised a question of pets' privacy and also the owner's privacy. I think this is one very good area that a lot of work has not yet been done in this regard. But however, given the telemedicine guidelines, I think interpreting them in terms of pets is going to be a really challenging aspect. And more specifically, I would like to tell you that as a veterinary doctor, you need to also ensure that the privacy of the pet's owner is also adequately protected, so as to ensure that you're compliant and your liability as an intermediary goes down to the bare minimum. So this is one scenario that I thought of sharing it with you. And one more such scenario is that yes, telemedical consultation using video calls. See what happens typically. It's a human tendency that whenever I'm talking or when you're listening, you typically nod your head. So can nodding of your head turn out to be the gesture of acceptance? Is one more such area which was interestingly quizzed. I think that is also one thing that the doctors need to keep in mind, because it's not just the physical consultation that you're likely to do here, but it's specifically the electronic consultation, and more specifically that you're not physically administering the patient, or you're not readily available, or you're not able to physically see the patient while assessing the condition. So any of these gestures, a nod of the head also could indicate acceptance, and that could bring in a lot of cyber legal, ethical, and what do you say, ramifications. And the doctors need to be really staying alive to this fact. So this is one more area that I thought of sharing it with you. And more specifically, when you look at what has happened recently, I think there's also a burst of fake Ayushman Bharat website, which was wherein 4,200 victims have been identified. The cybercrime unit of police have busted a gang who were trying to provide some kinds of jobs through this particular government website. I think this is also one thing that we also be alive. Telemedicine platforms or doctors are not immune from cyber crimes. I think there could be a lot of areas like identity thefts, or whether it's cheating by impersonation, violation of personal privacy, and the like that is going to happen. More specifically, phishing is also going to happen. So, more specifically, I would advise you to just think of these basic parameters, and then keep that in mind, and then do your telemedical consultations, so as to ensure that you're on the safe side and not going on the other side of the law. So, I think everything becomes hunky dory so long as there is nothing going wrong. And the tipping point is that basically, if you're able to understand the legal nuances relating to telemedicine and then go further, I think that's going to be a lot of that's going to be bringing in a lot of effective implementation, and that's going to really make you and make the telemedicine doctors enjoy your consultations without committing any kinds of historical or legal mistakes. I think this is one area that I thought of talking to you all about. And think fundamentally, a lot of capacity building and then knowledge sharing needs to happen in this regard. A lot of more cumulative efforts need to happen to strengthen these guidelines further. I think we cannot walk the walk without having in place all of these addressed. And more specifically, with artificial intelligence and the like coming in, it's going to be completely a different paradigm altogether. So that's all I have from my end. So it's been a good day to talk to all of you. I think I once again thank Law Essentials for this wonderful opportunity. And then I'm open to questions if there are any. So thank you so much once again. I think I tried to bring in some kinds of situations, and more specifically, the panic that is happening around these telemedical legal consultations.
Thank you so much, sir. I think that session was very insightful to our audience. We will now be taking up questions which the audience have put forth to us throughout the session. So Shivani Supriya asks, sir, can you please state the difference between private and sensitive information?
Yes. So any information with which you can identify an individual becomes your personal information, private information. And sensitive information, the law is very clearly stipulated So it could be passwords, financial information, it could be the health records, medical records, biometric information, sexual orientation. I think if you're under these 6 aspects, you could be called as a sensitive personal information, and any other information that is used as an identifier can be a private information. So this is what I can tell you as of now with regard to what is private and what is sensitive information.
Moving on, we have another question from Abhinav Anand. He asks whether we can tell him what kind of remedy will be available to the patients in case there is any breach of their data.
Excellent. Abhinav, this is a very valid point that you have pushed in here. There could be typically 2 kinds of legal remedies that you could look at. Look, you could look at civil remedy, you could look at criminal remedy. So civil remedy would be that you could get compensation by way of damages, and criminal remedy would be for lodging a criminal case against the respective doctor or the medical practitioner indulging in this medical malpractice. So typically, you can also make use of the provisions if you're a law student or if you're a lawyer and you intend to know more about the sections, then you could make use of specific sections, specifically under 43A of Information Technology Act, 72, 72A, as also if there is an intention that there's no proper due care or exercise being covered, I think Section 43 also will come into picture. And if there was a breach of your information and confidentiality, 72, 72A also would come into picture. So you could basically make use of either a civil remedy or a criminal remedy, or you could also make use of the general legal remedies. That is, typically this is a contractual relationship, so contractual remedies also may come into picture here, because when you're talking about these platforms, especially when between the platform and the patient, yes, it's a contractual relationship, because the moment you're accepting the terms and conditions of the platform, only then you'll be provided with access to the platform. I think that is also one more area that you need to look at.
Rudra Shandelia asks, could you please elaborate Disha and its relation to the telemedicine sector?
So that's a very interesting question, as far as I'm concerned. But what is the exact thing that you're looking at in terms of this? What do you want me to exactly specifically look at?
So I think we'll wait for his response. Moving on, we'll have another question from Sapna Rajmani. What are the liabilities of doctors on violation of telemedicine laws?
Sorry, I didn't get you. What are the liabilities of doctors on? Yes, the doctors would have some kinds of liabilities. For example, when you look at failure to exercise due care or duty care, or duty to have proper care, I think criminal liability could be one of the areas that they could focus. Vicarious liability could be one of the areas, and if they're not complying to the telemedicine guidelines, I think professional misconduct also is one of the one of the liabilities which the guidelines have stipulated. And more specifically, there could also be civil remedies that you could make use of in case of a compensation, that is damages by way of compensation. And you could also make use of liabilities under the Information Technology Act in case the privacy, the data, and the confidentiality of the patient is actually breached by the doctor. So there are these kinds of liabilities that I can see as a landscape of liability in terms of telemedicine. Yes.
So the next question is, sir, as the word privacy is not defined anywhere, how can you ensure that in telemedicine law?
The question isn't making, I mean, second part of the question is not very clear. Could you just ask them for a clarity? How can you ensure that in telemedicine that it's leaving something abrupt? I think I would require more clarity on that.
Okay. So we have another question from Rudra. He says, sir, there is a big debate on the difference between anonymity and privacy. Could you throw light on the same?
See, anonymous data basically is something with which you can not identify any particular individual or a person. So anonymous data, usually what happens is when you visit a particular, see, I'll tell this in terms of a website so that you can probably relate to it. When you're opening up a website, let's say that you're opening www.google.com, there is some amount of anonymous data that is getting recorded on the server. For example, your device location, if you have access to a computer, the details of the computer, if you have access to your mobile or a device, the device related information, there are some specific anonymous data that gets recorded. The browser type, and the device ID, the device details, the kinds of things that are anonymous. So these are bound to happen because when you basically open a website, access it, this is the underlying thing that happens at the back door. So this is called an anonymous data, and it cannot identify any particular instance or an individual. So this is a basic difference, and sensitive or personal data is very specific in identifying information. So that is the difference between anonymous data and this data. Anonymous
The
data
next
is usually analyzed for the purpose of doing analytics, like how many people have visited your site, what is the time that they have spent on it, what are the different areas, how many people visited on this time, but during this time, all these stats would be available in order to provide a better reach to them, so as to do a better study on the improvement of their services. That is usually the anonymous data. They use it for research and marketing purpose also.
The next question we have is, what will be the intermediary's liability in case of any breach with regard to patient's data?
See, two factors here. The first thing is that, see, as a technology provider, I am supposed to exercise my due care and diligence. So the moment I exercise my due care and diligence, I will be exempt from liability. But here, with regard to patient's data, the complete onus, as far as the guidelines are concerned, is with the doctor, and it's not specifically with the platform provider. So as a doctor, I am also an intermediary because I'm providing certain services. I'm collecting electronic records, which is the patient information, and I'm providing a service to that record. So in that light, I can answer and tell you that the intermediary liability, which with regard to the breach of a patient's data, can have two things: civil and criminal. Civil could be by way of compensation up to 5 crore rupees per contravention. So with regard to the patient's data, the intermediary is liable. Liability would be having four policies. So typically having privacy policy, terms and conditions, grievance mechanism, and a specific user agreement relating to the data. So if the intermediaries have failed to have any of these, and as a result the breach has taken place, then you can sue them up to 20 crore rupees as far as the damages are concerned. Now, as far as criminal liability is concerned, if the same has happened due to the negligence of the provider, yes, there is section 66 that will come into picture. If they're not exercised due care and diligence, where protecting your confidential and patient information, 72 72A also would be applicable. So there would be fines ranging from 1 lakh to 10 lakhs, and imprisonment from 3 years to life imprisonment. It all depends on the magnitude and the quantum of offense being committed. So typically here the platforms would have to very specifically address, if they're storing or giving an option to the doctor to store the patient's data, they have to also protect themselves in terms of having due diligence under the law. And if you're a doctor or a medical professional, I think the same would also apply to you, because you're supposed to maintain confidentiality and ensure that the patient information is not leaked out anywhere in the public domain. So in this light only, I was also trying to talk about WhatsApp. Primarily using WhatsApp, I think even the doctors would have liability in this regard, and more specifically, they would also have a vicarious liability, because they exercised, they got an option to make use of some other tools, but they have not exercised their what do you say, power and due care and diligence, and still gone ahead and enabled that breach. So I think that is going to bring in a lot of different what do you say, legal Pandora's box of exposures. But I think more specifically, these are some things that I'm able to see specifically in the light of patients' data.
Aishwarya Bindu asks, Sir, as the interaction is online and if a third party is involved, what if there is a leak or misuse of information is done by a third party? How will it be protected by the law?
Um, Two things. First thing is that the doctor would be exempt from his liability in this regard, because the telemedicine guidelines have stipulated that for any breach that is relating to, for any data breach relating to the technology glitch or technology issues, would be the liability of the platform provider. Now, the second thing that is going to come into picture is liability of the platform provider. Now, if the platform provider has his due diligence in place, that means he is exercising his privacy policies, he's having these documents duly drafted, he's able to demonstrate that he has taken his due diligence, and the information leak or misuse has happened beyond control, he will be exempt from the liability under section 79 of the IT Act, which specifically says that the intermediaries are exempt from certain cases, more specifically if they are exercising due care and diligence. Because this is totally going to be a clueless world, because we are all living in a way where the online world is going to expose us completely to darkness. So I think that is one kind of aspect which is not going to be there in the physical world, because physical world, at least you know that your data might only be within the boundaries of that particular respective clinic or hospital. But I think online it's totally going to be a different aspect altogether, and more specifically with the internet making geography as history, that could bring in a lot of different cyber legal challenges. So in that light, so the liability of the third parties would be, in case they have failed to exercise due care and diligence, they are negligent, and they're aware or cognizant that such a breach has taken place. Yes, section 85 under information technology also can be used under this scenario, and then yes, liabilities could be in that area as well.
So we have another question from Tanisha Sarangi. What if the jurisdiction issues rise up? Where can we file a case? In which courtroom or a forum for grievance?
That's an excellent question. I think it is going to bring up a lot of thought process in that area as well. Now, jurisdictional aspect will be two things here. First thing, the platform that you're making use of. So, in its terms and conditions, all of us are aware that while you're making use of a platform, we are governed by the terms and conditions set forth in that platform. So, we need to clearly understand which is the jurisdiction that has been mentioned in the terms and conditions. Since we are accepting that, one way of looking at it is that will be the right area where you can go and file a case, because that is clearly mentioned there. Second aspect is when you look at the specific breach happening with regard to patient's data, because the doctor may be physically located in one place, the patient may be located in one another place, and the platform that is making use of may be located in one another place. So one more interesting area that is going to bring in a lot of amount of ticklish questions is how do you address this scenario. So basically, wherever the cause of action has arisen, if we're able to demonstrate that the cause of action has arisen in the doctor's place, but specifically because the onus on protecting the confidentiality and the patient's data is vesting with the doctor, I think that is one area that we can try to consider, and then file your cases in those areas. So this is going to be having multiple answers, because this is going to open up a lot of thoughts processes. There's no absolute clarity on the jurisdictional aspect, but with internet making the entire world as a boundaryless world, I think this is going to be a very, very interesting challenge that we should see as time passes by.
Rudra clarifies the question which he had asked earlier. He asks, does Disha provide stricter liability and better execution of the provisions as compared with the erstwhile IT Act?
See, Disha is only, as far as my understanding concerned, is it is just on the only in the what do you say, regulation rules phase. I think no enactment has happened with regard to the Disha guidelines. They've only been put up in the draft bill kind of a phase. I think it'll be interesting if the same thing becomes an act. Then we would be able to probably state which is going to have a stricter enforceability. The point here is that it's not enough that we bring in the regulations. I think implementation should be one of the areas. See, I would say that the complete Indian cyber law is like a historical mistake, because and a toothless wonder. Why? Because once the act has come up in 2000, it has made a lot of offenses as non-bailable, bringing about a seriousness with regard to the offenses. But when the same thing was amended in the year 2008, I think the whole punishment mechanism has been withheld down, which is meaning that every offense which is there, every offense committed under IT Act is now being bailable offense, which means that the bail can be a matter of right. So therefore, this also has to be specifically looked into from that perspective. But apart from this, I think the implementation aspect is one more area that needs to be quickly addressed. And now slowly with everybody moving on to telemedicine, I think a lot of work has to be done with regard to implementation of these guidelines, because April 11th 2011 has been a watershed day in the history of India. Why? Because April 11th 2011, these IT rules 2011 were enacted. And I can say that uh, uh, on an average, when you look at the awareness level in India, out of 100 people, I think 99% people are not aware. 0.5% people are slightly aware, and other 0.5 people are doing something more. But unfortunately, the awareness is not picked up as it was supposed to pick up in this domain. So Disha, I think it has not yet been introduced into a bill phase, and it's not been made an act. I don't want to comment on it because there is no what do you say, legal sanctity to the same. And if the same becomes an act tomorrow, and I think that will be helping us to determine the effectiveness. What is important is not being not just addressing the concerns, but implementation is going to be a key role in terms of how do you implement that. The implementing factor is going to be a very very important piece of what do you say, tipping point that the government has to ensure, so as to ensure that whatever laws are enacted take effect. And typically we're able to have some kinds of what do you say, convictions for what do you say, breaches and violations. Otherwise it becomes no, it just becomes a paperless tiger.
With this, we come to the end of the session, sir. We are very privileged to have you with us today. I would like to thank you on behalf of the entire team of Law Essentials for taking your valuable time out for conducting this wonderful webinar. I hope everyone has enjoyed this excellent and enriching session.
Thank you so much. Once again thank Law Essentials and the host specifically, so as to give me this opportunity. And it's been pleasure to talking to all of you here. Thank you so much.
We also have the 8th edition of the webinar coming up. It is on writ jurisdiction, principles and practice. The host of the session will be Senior Advocate Aditya Sondi. He is the former Advocate General for Karnataka. He is also an advocate practicing at the Supreme Court of India and the Karnataka High Court. And currently he is also a visiting faculty at the National Law School of India, University, Bangalore. For registration of the same, you may log on to www.lawessential.com. Thank you so much for attending the webinar today. Thank you, sir.